LG Park HT1 Ltd and all, and the commissioners for His Majesty's Revenue and Customs.
Yes, Ms. McCarthy.
Good morning, my ladies. I appear on behalf of the Appellant HMRC with my learned friends Mr. Ripley and Mr. Hellier, and Mr. Baldry, King's Counsel, and Mr. Windle appear for the respondents. To avoid confusion, because obviously the parties have different labels below, I'll simply refer to them here as HMRC and the taxpayers.
Certainly.
If I can just start with a couple of housekeeping points.
Yes.
I gather that in fact the court has approved transcribers to attend remotely.
Yes.
Should I therefore be building in a short break in the morning?
Well, I haven't been asked for one.
Okay, I'm not sure what the expectation is. We were simply told very recently that they were attending.
Right. Oh, well, I apologise. I presumed that you had been informed that a request had been made for transcribers.
We have been informed, but I don't know what their expectations are because the taxpayers organised them.
Yes, my understanding is that the transcribers are expecting a break at 90 minutes in. I'm sorry the court hasn't been informed of that.
No, we haven't. But no, don't worry. Certainly we'll deal with that, yes.
Thank you. So I'll in that case, I'll try and remember to pause at 11:30.
Certainly, thank you.
The next question by way of housekeeping is I was intending in terms of bundle references to give tab numbers and PDF page numbers, depending on...
That's very helpful, certainly.
Thank you. Next point is we realised that the chronology that was at core tab 6 was out of date.
Yes.
And so we applied to amend the chronology yesterday.
Yes.
In case it assists, we also have a tracked change version that's been produced in hard copy. You will just...
Any objections?
No.
No, that's fine. Thank you.
And then finally, has the court had the opportunity to read the skeleton arguments and the identified pre-reading?
Yes, we've had the opportunity of reading both judgments, the skeleton arguments, and I think we've all dipped into the major authorities, so you can take it that we've had an opportunity of doing a considerable amount of reading.
I'm most grateful. That's extremely useful.
Just before we start, can I thank all of both the parties and those sitting behind you for sitting at 10 for my personal convenience. I'm very grateful.
Not at all, no problem. So, starting off with how I intend to order my submissions, what I want to do is start off by setting out the substantive dispute between the parties and how the substantive issues have evolved. That's somewhat convoluted, but it's necessary to understand because it's relevant background to the Para 45 application. I then want to take what will be a quicker look at the procedural chronology. Then I intend to make my submissions on how we say Para 45 should operate, first of all in principle, and secondly in this particular case. Then what I want to do is turn to the decisions below. And if I may just set out now what we say is the correct approach to the decisions below and what this court should be seeking to do. We say that at the first question for this court is to identify whether the first-tier tribunal made a material error of law. And I emphasise, as we did in our skeleton argument, the word material. We say it didn't. If we're right about that, then analytically, we can stop there. If there's no material error of law in the first-tier's decision, then the Upper Tribunal must have necessarily fallen into error by finding opposite, and the first-tier's decision should just be reinstated. Now, if we're wrong on that, we'll move on to the next stage. If the first-tier, if this court decides the first-tier did make a material error of law, we then look to the Upper Tribunal decision, and the second question is, in that decision, did the Upper Tribunal make a material error of law? If not, the Upper Tribunal decision stands. But if we can establish at that point a material error in the Upper Tribunal decision, we say this court can and should set it aside. It should remake the decision. And at that point, when this court remakes that decision, we also say that the court should consider all the circumstances as at today's date, including relevantly the substantial progress that has been made in the first-tier tribunal substantive proceedings since the Upper Tribunal's decision. And finally, I'll make what I intend to be only brief submissions on the respondent's notice.
Thank you, that's most helpful.
So then, starting off with the first stage, my submissions on the substantive dispute and the evolution of the substantive issues. The background is set out at Upper Tribunal paragraph 3, which for the note is Core Bundle tab 7, PDF 81. But if I can just break it down into what we see are really the nub of what's been going on. In short, the taxpayers operate ports and shall, right at the outset, owned old oil refineries.
Sorry to interrupt, I had my judgment, the tribunal judgment, separate. I think my clerk's inadvertently left it on my desk. Excuse me. Could you contact Sean for me, my clerk, Sean, for me, and just say that the judgment is on my desk. Could you please be let in?
I've got mine electronically.
Oh,
for now.
yes.
For now.
And we also have a clean copy if it would help.
You have that thing? No, yes, please.
Yeah.
Mine's marked up, but it'll reappear in due course. No doubt will open on its own at paragraph 44. Is there a problem if I write on this?
No, not at all. I think you can simply keep that copy.
Yes.
So the facts are set out in some detail at paragraph 3, but really, if I can just stand back from what's written there, the real nub of what's going on is this. In short, the taxpayers operate ports, and right at the outset, Shell owned old oil refinery land. Now, in 2000, the taxpayers and Shell entered into agreements in principle where the taxpayers would acquire what is being referred to as the port land in order to build a port, and the park land in order to build a logistics site. Move forward to 2008 in order to start to put this into action. Shell sold the port land to the taxpayers.
Well, it's not strictly these
Yes, my lady's quite right. It's not strictly these taxpayers, but I think the change in ownership, so far as we see it, doesn't necessarily matter. So I think just for
it's a company called referred to as LG Ports, I think.
It is, but for simply the purposes of setting out the background, I don't think the particular taxpayer or the change in ownership necessarily matters. Not least because actually this court isn't being asked to make findings of fact about the underlying dispute. And I just want to keep it really simple so that we can see what the issues are and how they evolved. So Shell sold the parkland to the taxpayers.
Portland.
I'm sorry, the portland to the taxpayers. I'll show the relevant clauses in the agreements in a moment, but very broadly, under that agreement, who I'm referring to for the moment collectively is just the taxpayers, in contradistinction to Shell, were required to construct a port to certain standards by February 2013. Shell was granted a call option so that if the taxpayers failed to construct the port, Shell could repurchase the land for a set price. Now, as we understand it, the original idea had been that the taxpayers, together with Shell, would go on to operate the site together. But matters changed, again, as we understand it, possibly in part due to a change of ownership of the taxpayers. Things took a different course, and the new commercial arrangement was simply that the taxpayers would take over the whole site themselves. So in late 2013, 2009, and early 2010, Shell then sold the parkland to the taxpayers. Parkland was divided into 10 plots. Shell granted 200-year leases over the 10 plots, and the total consideration, so if you add all the considerations in all the leases up, was roughly 116 million plus VAT. The next day, Shell then transferred the freehold to one of the taxpayers, LG Park Freehold, and the parties executed an omnibus deed, which, among other things, caused the minimum port requirement and the minimum port requirement option to cease to have effect. Now, what this dispute concerns, the underlying substantive dispute, is the SDLT on the 200-year leases that were sold collectively for consideration of 160 million plus VAT. The relevant SDLT returns that are subject of the closure notice appeals reflected total chargeable consideration of only 30.6 million. And so the parties are in dispute over what HMRC says is the substantial shortfall between the price paid and the chargeable consideration that appears in those returns. What I now want to do as part of this background is briefly turn up a couple of key provisions in the documents so you've seen them. So there are 3 documents and they all appear in the supplementary bundle. So the first document I want to go to is tab 1 of the supplementary bundle, PDF page 3. This is the agreement dated 6th of March 2008. And as you can see, this is transfer of part of the registered title of the freehold land at Shellhaven Oil Refinery. So in other words, this is the sale of the port land by Shell to, for these purposes, taxpayers. Can I ask you please to go to PDF 14, and it's clause 19, which is the minimum port requirement, and I'd be grateful if the court could just briefly reread clause 19, the minimum port requirement. And so, very broadly, the taxpayers agree with Shell, so taxpayers, the transferee, agree with Shell, the transferor, to conduct one or other type of berth. If they don't do so, as compensation instead of damages, Shell may require the taxpayers to transfer the land back at a specified price. The next document that I'd like to go to, please, is supplementary tab 2. This starts at PDF page 30. Now what this is, and you can see you've got a document dated 14th of January 2010, and this is a lease to LG Park HT10. So essentially this is the lease of what is plot 10. This is just an example of one of the 10 plot leases where the taxpayers agreed to acquire the parkland from Shell for a total of 160 million plus VAT. And if we could look briefly, please, at 33, page 33, you can see set out the parties to the lease. Shell is the landlord, and the relevant taxpayer company is identified as the tenant. Over the page, page 34, the term is 200 years, and you can see identified there the premium. The premium is obviously a figure less than 116 million. This is the premium that was for plot 10. If I can ask you to move on to page 36, please. At top of page 36, the parties are identified as shall, and relevantly, the landlord includes successors entitled to the reversion of the lease. Scrolling down, please, to page 37, the definitions. Again, landlord there is defined to include the immediate reversioner. Now, moving forward, please, to page 40, at clause 2, clause 2.1, shall demises the property to one of the taxpayers in consideration for the premium, which we've already seen is the cash amount, and the grant of land options by that taxpayer to shall. And as we can see, those options are set out in clauses 7 and 8. That's page 41 and 42. Now, in effect, we say that these appear to give shall the option to, first of all, and so this is clause 7, acquire part of the property to satisfy certain planning considerations or to construct certain infrastructure. Now, pausing there, you may say, well, hang on, why is shall doing this if shall's stepping out of the deal? Now, we understand that the purpose of this was to be that at the time the plot leases were granted, the park infrastructure was unplanned. The taxpayers had it in mind that the plots might be sold on to unconnected tenants by them. And if that happened, they could foresee difficulties arising in arrangements to construct connecting infrastructure. And so those options were designed to address that issue, and that's why it's important to note that landlord is not just shall, it's shall and reversion is entitled. And one day later, that then, as the freehold was granted to a taxpayer company, became the taxpayer company.
Sorry, I'm not sure I quite follow. When you say that plots might be sold to unconnected third parties, are you more referring there to the tenant? In other words,
yes.
The protection ensures that the tenant, if a new third party, is bound by these options.
Yes, I think that's right. So the point is, in one sense, if who was DP World or LG Park owns everything between their own companies, doesn't really matter because they can.
Yes, but if one of the plots is sold or the company
exactly
is sold,
to an unconnected tenant,
which has happened in one case.
Yes, then the option enables the taxpayer company who then owns the freehold to say to that tenant, we need the interest back in order to build the infrastructure. Yes. And that actually right there raises an important point. What's any of this really got to do with shall? But shall's dropping out the picture, and I'll come back to the relevance of that in due course. So that's clause 7. Clause 8, unremediated land. This enables shall on day 1, but 1 day later, a taxpayer company to acquire part of the property requiring remediation. Now, the context of that clause is that shall had continuing obligations to the taxpayer under a separate environmental deal should any land require remediation because of contamination from the old oil refinery. Now, I've already emphasized...
Sorry.
I'm sorry.
Shell had previous obligations, but is the point again so that, if necessary, land can be got in from an unconnected tenant?
That's what we understand, yes. And I say, on the face of it, these options appear to involve Shell. But, as I've already made the point, the day after the leases were entered into, Shell then transferred its freehold interest to the taxpayers, another taxpayer company, and you'll have also noticed that landlord includes successors in title. And the other important point to note at this stage is when you look at both Clause 7 and Clause 8, the actual surrender of various parts of the land, once the option's exercised, come into effect 5 working days after the landlord serves written notice. And that's relevant because we say, in other words, as we understand it, Shell could not itself ever regain an interest in land because of that timing disparity. And I'll come back to the relevance of that when I get on to the substantive issues. So the last transaction document, Supplementary Bundle Tab 3, PDF page 66, this is part of, it's not the whole omnibus deed, it's part of the omnibus deed dated 15th of January 2010. And we've only included one of the schedules. So you'll see it's Schedule 4 has been included, page 67. And if you look at Part 2, variations to port land transfer, and over the page, PDF 68, you'll see Clause 8, Paragraph 19, which, as you'll recall, is the minimum, Paragraph 19, which, as you'll recall, is the minimum port requirement, shall cease to have, is one of the paragraphs that shall cease to have effect. And so those are all the documents that I need to show you for our purposes. So, now just to give a bit more context, I'd like just to turn to the SDLT treatment. So taking this in stages, we're interested in the SDLT due on the 10 peak leases for which the taxpayers paid Shell 160 million plus VAT. If I may briefly summarise and show you some of the key legislation, and I apologise if this is already well understood by the court. SDLT is payable in respect of land transactions. A land transaction includes interest in land, but not exempt interests. SDLT is payable by the purchaser, so here the taxpayers, and it's charged as a percentage of the chargeable consideration, in inverted commas, that's given for that acquisition. And chargeable consideration, I put in inverted commas because depending on the circumstances, it can be different things. So starting off, if I may, in the authorities bundle, please. If I could ask you please to turn up authorities tab 3, which is PDF page 9. And here we have Finance Act 2003 Schedule 4, which is the schedule containing the provisions about chargeable consideration. And you can see from paragraph 1, the chargeable consideration for a transaction is, except as otherwise expressly provided, any consideration in money or money's worth given for the subject matter of the transaction, directly or indirectly by the purchaser, etc. Now, you'll recall clause 2 of the example plot lease, and if you want to turn it up again, supplementary bundle, tab 2, page 40. But if we ignore the options for the moment, ignore the minimum port requirement and the dispute about that, in consideration for 116 million paid by the taxpayers, Shell demises the plot lease. Now, if that were the only deal, and if it was all agreed that that was the only thing going on, then the consideration given is the 116 million plus VAT. SDLT is due on 116 million plus VAT, and that's straightforward. Now, if we still ignore the minimum port requirement dispute, what's the position if we take account of the options? So these are the options that were notionally granted to Shell. Now the deal becomes taxpayer buys the property in return for 116 million cash and notionally these two options granted to Shell. A question then arises, how does that affect the SDLT analysis? And it's relevant, please, to go to Authorities tab 1, PDF 3, which sets out provisions in relation to exchanges at section 47. And if I could ask the court just briefly to read section 47, sub 1 and sub 2 to itself, please. And so, very broadly, the point is there is an exchange. If I buy an interest in land, and in consideration either in whole or in part, I give an interest in land. So the potential questions that arise here are, is it right to say that the two options granted to Shell are in consideration of, within the meaning of section 47, in consideration of the land it's selling to the taxpayers, in circumstances where Shell can't actually realistically benefit from the options being exercised on any view. Now, the taxpayers may dispute how I've characterised the options, and the taxpayers disagree with what I've said about in consideration in relation to section 47, but that's just outlining the exchange issue and how that fits into this case. As matters currently stand, our up-to-date first-tier tribunal statement of case expressly puts the taxpayers to proof on the existence of the exchange. Why do we care if there's an exchange? Because it affects the chargeable consideration, and you can see that from Authorities tab 4, PDF 11.
Sorry, tab 4.
Tab 4 at PDF 11. And here we're back in Schedule 4 of FA 2003, which is the schedule that defines chargeable consideration. We're interested in para 5. And para 5.1 is saying this paragraph applies in effect if you have an exchange. The wording mirrors the wording in section 47. Subparagraph 3, and just to set it out broadly, if the subject matter of the exchange is a major interest in land, and here it will be because it's the 200-year plot lease, then the chargeable consideration, it is no longer the money that was given, it's the market value of the plot lease. And the taxpayers submitted their land transaction returns for chargeable consideration totaling 30 million, and we issued closure notices charging SDLT on market value consideration 116 million. And now we want to put the taxpayers to proof that the deal was indeed an exchange. So pausing there, and I'm still ignoring the existence of the minimum port requirement dispute. Simply these issues in the dispute that is the subject of the closure notice appeals are, what is the scope of the closure notice? In other words, can HMRC put the taxpayers to proof at all that the deal was an exchange? Or has HMRC in effect conceded it by what they wrote in the closure notices? Assuming that the exchange point is live, is there an exchange? If there is an exchange, what is the market value? But if we're allowed to take the exchange point and there isn't an exchange, no one cares about market value because the chargeable consideration is the money given. We all know what that is by looking at the premiums set out in the 10 leases and adding them up.
So on that thesis, the consideration would be exclusively for the grant of the leases.
Yes, because we're ignoring for the moment the dispute about the minimum report requirement.
Yes.
So in other words, you're saying that even without the minimum report requirement issue, it is possible that the
No one cares
result
about market
could be
value.
that market value
Doesn't
Yeah.
arise at all.
That assumes that when it comes to trial in the FTT, you are indeed permitted to argue
The exchange
the
point.
exchange point.
And
I'm sure that is not. I'm sure that is a matter in dispute.
That is a matter of dispute. Exactly right.
Yeah.
Exactly right. But if I may interject, and I'll come back to show you the relevance of this later. At this moment in time, the first tier declined to decide the scope of the closure notice point in the application, and the Upper Tribunal, and I paraphrase, said, well, we might have done it differently, but we accept that the scope of the closure notice is a matter for the first tier, and we also can't see that the first tier was so wrong in failing to decide it that we should set aside its refusal to decide. So at the moment, the scope of the closure notice point is a live issue in the first tier tribunal debate.
Right.
Now, my learned
And presumably would be decided at the substantive
Exactly.
hearing if
assuming no one
outcome
makes a
of this.
preliminary application.
Yes.
Yeah, exactly. So that's the status. Now, my learned friend in their respondents notice says, no, the Court of Appeals should decide. I'll come on to that and why he's wrong on that later as part of my submissions about the respondents notice. So at this moment in time, the scope of the closure notice, even on the basis of the Upper Tribunal's decision, is a live issue in dispute before the first tier tribunal in these proceedings. If we're right about that, if we're right about exchanges, nobody cares about the market value of anything. And the Lands Chamber need not be troubled. And that's critical to appreciate when you look in particular at the Upper Tribunal's decision, because one of the central planks in the Upper Tribunal's decision is market value is central to everything, and even more relevantly, it must be decided at some point. So let's transfer now. And that's why we say other things are wrong about the Upper Tribunal decision, but that is a fundamental error in terms of what's going on here that's wrong on any view. Now, at this...
So you say that even before we get to the MPR, that it is possible that market value will be irrelevant.
Exactly.
If you're allowed to argue the exchange point.
And whether or not we're allowed to argue it is currently alive.
And that's a matter for the
And that's
FTT.
it. Exactly. And that's it.
And it's agreed that that's a matter for the first tier tribunal?
So the respondent's notice effectively says the Court of Appeal should in fact decide that now.
Well, setting that aside.
But
for a moment,
setting that aside,
if we decide...
it is agreed, and what I'll show you in due course are the parties' current pleadings as at today's date, if you like, which actually set out two very comprehensive list of issues, which show quite clearly that market value is one of a whole number of issues. And I'll get to that shortly. So at this point, just to give you the proper context, I want to bring the relevance of the minimum report requirement into the dispute.
Yes.
So closure notices were issued in 2013, and I'll come back to those in due course. before the closure notices had been issued, there had been a dispute between the parties as to the relevance of various other, if I can call them commercial matters, the relevance that they had on the market value of the land. After the closure notices had been issued, and in fact in 2016, December 2016, the taxpayers raise, and I don't think I'm speaking out of turn, a new argument, which is not simply there are commercial matters that mean that actually the market value is less than the sticker price, is less than the contract price. But actually, that contract price was not just paid for land, it was paid for land and something else. So you've got one contract price that wasn't just paid for land, it was paid partly for land and partly attributable to something else. That other thing, as we'll see, is the release of the minimum port requirement, and the taxpayers say that's an exempt interest. So using some hypothetical figures for the moment, you've got 116, let's just say for argument's sake, the argument would be 100 was attributable to the land, 16 was attributable to the minimum port requirement. That 16 can't be chargeable consideration on any view because the minimum port requirement releases an exempt transaction. That's the nub of that argument. And you'll see that most clearly from supplementary bundle, tab 16, PDF page 141. And so prior to this point, the debate had been the market value of the plot leases was lower than the 116 actually paid. But now, in fact, it's clear from this letter that the taxpayers are introducing a different argument, which is, if I can paraphrase it this way, contrary to the appearance of clause 2 in those plot leases, the 116 million was not paid solely for the plot lease. In fact, and you'll see this from paragraph 1.1, a significant part of the consideration was paid for the release of the minimum port requirement, i.e. Shell's buyback right, and they say that that was an exempt security interest. And if I could ask the court please just to scroll down or go through the letter to PDF page 143, under the heading Alternative Reasons Why the Release of the NPR is Not Chargeable to SDLT, Norton Rose, for the taxpayers, raise arguments in the alternative. One, as you can see, 2.1a, Shell's buyback right, so the NPR option was not an interest in land. 2, over the page, B, the NPR option was an unenforceable penalty. So Shell's buyback right was an unenforceable penalty. So pausing there, the dispute had previously concerned the market value of plot leases. And the argument, the taxpayer's argument was they'd overpaid. So although 116 was actually given for plot leases, it was more than the plot leases were worth. But this new argument is actually saying 116 should be attributed to two separate things, part for the land and part for the release of the NPR. If I could ask you just to go now to the legislation so we can see why that's relevant, or where this has come from, how this relates to the SDLT issues. So it's Authorities tab 2, please, which is PDF 6, Finance Act 2003, section 48. That sets out what is the chargeable interest. And you'll see from 48, 1A and B, chargeable interest means various interests in land, other than an exempt interest, the tailpiece of 48.1. And then you'll see 48.2a, any security interest is an exempt interest. 48.3a, the definition of security interest is, etc., as you can see on the page. So pausing there, introducing this dispute about the NPR option has created new tax issues, and also issues about what are the facts of the commercial deal, and also a contractual interpretation point. How do you interpret clause 2 of the plot leases? What is that money for? If the money is only paid for one thing, then we're back to the exchange issue. Depending on the outcome of the exchange issue, the consideration might just be the 116 million that you see in the contract. If that 116 million was in fact paid for two things, then you have tax issues. We obviously know that whatever part of that was paid for the land is a chargeable interest, is chargeable to SDLT. What about the amount that we're apparently now attributing to the release of the NPR option? Is it exempt? Is it taxable? And overshadowing all of that is another potential question. What relevance to the NPR option release piece is the exchange treatment analysis? Because depending on if it's an exchange or not, will tell you how much of the price is the relevant chargeable consideration, assuming that the release is a chargeable transaction. So it is a little convoluted, but that's...
Sorry, what you're getting at there is that if there is an exchange, it might affect the calculation of the SDLT on the release of the NPR option, if that's chargeable. Is that what you're saying? I think that...
yes, that was what I was saying. Now, for reasons that I just think are too complicated to go into for the purposes of this hearing, there's a separate issue as to whether or not there's an exchange in relation to the NPR, which
all I wanted to clarify is my understanding, because I think you've raised it in the skeleton, that there is a possible point, you say, about the relevance of exchange treatment in relation to the NPR.
Exactly, and I don't
which
want
goes
to
to the discovery assessments.
Which goes, exactly right, which goes to the discovery assessments.
Yes.
And I would say no more than there's a possible point, because anything else just becomes overly complicated.
Yes, thank you.
Now, but pausing there now. Oh, I'm sorry, there's one more piece of the legislation that I need to show you. Let's assume for the moment that there is no exchange, but that 116 million was paid for two things, land and release. What then do we do with the 116 million? And this is set out in Authorities Bundle tab 3, page 9. So we're back in Schedule 4 that tells us about chargeable consideration. Now we're looking at Para 4, just and reasonable apportionment. And you can see for 1, for the purposes of this part, consideration attributable to two or more land transactions, or in part to a land transaction and in part to another matter, shall be apportioned on a just and reasonable basis. There's also a question as to how Para 4.3 should apply. And what Para 4.3 is doing, and this is over the page, is it setting out provisions in circumstances where the consideration is given for what is in substance one bargain. So are we in a Para 4.3 world? I think at this point we're all, well, I'm pretty certain that I don't know what I'm writing in a referral to the Upper Tribunal Lands Chamber if I had to write that today. That's my submission. Now, if I can just show you a couple of other things in the correspondence, and take too long. So back to the supplementary bundle. Behind tab 7, and this, I'm sorry, behind tab 17, page 164, this is HMRC's response, 27th of June 2017, and in short, we disagree with the MPR release analysis. And if I could ask you just to scroll down, please, to page 164. But what
So
you...
this is, yes, this is a reply in June to a letter of December.
Yes. I mean, yes.
Just saying.
What you'll see at PDF 167 is the revenue has set out proposed next steps. Now we've identified tax issues that we don't agree on. We, the revenue, suggest that we refer tax questions to the first tier and afterwards refer valuation. Now, Norton Rose replied to that letter, 9th of November 2017,
Tab 18.
which is the next, tab 18,
Yeah.
page 168. Now, next steps procedure at the bottom of that page. Norton Rose disagrees with the referral. Now, for reasons I don't need to go into, that's actually quite right because of where the inquiries had reached. It wasn't possible to simply refer that question. But they do agree in principle that a legal question should be put to the first tier. And then the last point that I want to show you on this is supplementary tab 19, page 170. Again, Norton Rose letter, 25th of January 2018. And at this point, Norton Rose say in the second paragraph, we appreciate your agreement to try and agree next steps and look forward to your thoughts on directions and the apportionment question. And then they say, in their fourth paragraph, starting, however, we strongly consider that, there was also a separate question of penalties.
Yes.
So they want to postpone the penalties appeal. And then they say this is because we consider that the narrow technical point of the meaning of security interest can be heard in a short time frame with minimal evidence. If DP World's position prevails, that would then dispose of the need for further debate on other issues, brackets, valuation, apportionment, penalties, etc. Now, all I want to say is that at this point there was a common understanding that the tax issues would be decided first, and depending on the outcome of the tax issues, it was perfectly possible everything else would fall away. Now, obviously, the taxpayers aren't bound by that. They've clearly changed their mind for reasons we don't quite understand, but that's certainly the position that was reached at that point.
For what it's worth, the implication also is that the security interest is the key point.
Yes, exactly.
Yes.
So just as part of the chronology, we issue our view of the matter letter, 3rd of August 2018, and this is the letter that's at supplementary tab 20, page 173, and the point of this letter is it's part of the formal process of now moving things from simply an appeal between the parties to the first-tier tribunal. So that's the status of this letter. If I could just draw your attention to PDF 175, please, you'll see in section 4 of that letter, we make 2 points. First of all, drawing their attention to our position in relation to exchange.
Sorry, where are we?
So this is page 175 of the letter that's behind tab 20.
Yep, I have it. The following additional points.
Exactly. Section 4 of that. So A, we draw their attention, the taxpayers' attention, to our position on exchange. And then B, we also say that the correct attribution of consideration to the MPR release may be nil. Now, I'm pausing there, and I don't propose to say this is a direct analogy, but just simply to set out our thinking. If I pay £1 million for a house and the vendor has a mortgage, then part of the contract will obviously be that the bank releases its charge. It's clearly commercially significant that that happens, but equally, is it right to say that some part of the million is actually paid for that event? Answer, no, the $1 million is just paid for the house. So that's the sort of thinking. Just because something may be commercially significant doesn't necessarily mean value is attributed to it. And I don't want to labour that point, but that's certainly, that was simply to explain the thinking behind that. There's then further correspondence. Tab 21, letter from Norton Rose dated 30th of August 2018. This letter now raises the issue of the scope of the closure notice and it not being open to HMRC to bring exchange back as an issue of dispute. There's another letter from Norton Rose of the same date, 30th of August 2018, behind tab 22. And if I can ask you, just for the time being, to go to page 180 of the bundle, paragraph 4.1, and this is in response to our suggestion that the value attached to the release of the MPR should be nil, and you'll see that Norton Rose in this letter call that fanciful in the first line, and the reason I've shown you this will become clear in due course. Now, the next document to show you is the Notice of Appeal to the First-tier Tribunal.
Sorry, yes, just we are passing over the fact that there was also a formal review before the appeal
Yes.
to the tribunal.
Yes.
I make that point because I think you haven't included all the right statutory references in the authorities bundle, but the review document is in the core bundle.
Yes, it is. You mean the statutory references
yes,
about
in the
review procedure haven't been
36s, I think
included,
you haven't included.
We haven't, and it's also fair to say, and I noticed last night, that one of the provisions about the rights of appeal haven't been included.
Yeah, I don't think it's material, but I just wanted to point that out.
Your ladyship is quite correct. And I don't actually, for reasons I will come on to when I deal with the respondent's notice, I actually say that all of that procedure and the framework and the scope question just isn't something the Court of Appeal should address. So
yes,
for my part,
I know you'll say that we shouldn't address it, but I just wanted to flag that most of the cases that have considered scope of appeals don't have 5 years plus of correspondence that follow the closure notice.
No, exactly.
So there is an issue there.
There is further context, which is, and the other point is, the court also doesn't have all of that further correspondence.
I'm very conscious that we don't have all the inquiry correspondence,
exactly.
and neither did the FTT.
Exactly.
And we don't have all of the further.
Exactly. Which certainly, from our perspective, suits how we say this court should deal with that.
So just for completeness,
yes,
I did read the review conclusion letter, which is at page 147 of the bundle.
So following that letter, the next document I want to show the court is the grounds of appeal before the first tier in the formal notice of appeal. This is core bundle, tab 12. And the grounds themselves are set out on page 143. And over the page to 144. And I assume the court has already had the opportunity to read these, so all I wish to do is note clause at ground 6 that the taxpayer disagrees with. So sorry, I should give you a moment. So it's page 143, and all I want to do is reiterate at clause 6: the taxpayer disagrees with the open market value contended by HMRC in the closure notice for the various reasons, including B, the grant of the plot lease formed part of a wider commercial agreement. Now, you'll note that in these grounds of appeal, there's no mention expressly of the MPR option, of the exempt security issue, or the question of attribution or apportionment. This, needless to say, caused us some confusion, because it having been agreed in correspondence that the security issue, etc., was the main issue and would be going first, the next thing we're confronted with is, in fact, the application for there to be a market value reference to the Upper Tribunal. In our skeleton argument before the first tier, which we don't have in the bundle but is referred to in the decision, we queried whether those matters had now been formally conceded. And our position, which comes through in the extract of the transcript, is if they have been formally conceded and market value truly is the only ground of appeal, then we don't object to the transfer. What I would be grateful for the court to read, perhaps during a short adjournment, is the short extract from the First-tier Tribunal transcript about this discussion, what the issues actually are before the First-tier Tribunal, and that is in the supplementary bundle, tab 24, pages 1, so there's bundle pages 184 to 188. And the reason for showing you this at all is because a lot of the submissions made to the First-tier Tribunal were about proper case management. So forget the conditions of para 45. Given where we are, what should the first tier do in terms of case management? And that is directly relevant to our first ground of appeal, because our first ground of appeal to this court is that the First-tier Tribunal made a freestanding, or gave a self-standing reason why transfer wasn't appropriate at that time because of case management difficulties. And so I think it's important that the court has seen the submissions that the first tier actually heard about what those difficulties were. And if I can just, I don't intend to spend much time on the summary now, but if I can just make a few submissions for your note, which you'll see in due course when you read the transcript. Internal page 80, you'll see that we raised the question, are the security interest and apportionment issues actually formally conceded? You'll see that I refer to a submission made by my learned friend in his opening to the effect that the post-closure notice points had, in inverted commas, fallen away. You'll see an internal transcript, page 81, the fact that I'd asked him during the short adjournment before the first tier, does fallen away mean conceded? And he said, no, fallen away does not mean conceded. So internal page 81, I invited the first tier to ask the taxpayers to clarify their position. Internal pages 82 to 88, there were then submissions by my learned friend, and the nub of those points, as we understood them, was that those points didn't arise in the appeal, but there wasn't a formal concession of those points, but there was some overlap in facts and circumstances which might be relevant to determining market value. And that you'll get from internal page 86. I then responded to say that's all very unclear, and specifically, the taxpayer's answer demonstrates why any reference to the Upper Tribunal is now premature. And that's internal page 89, specifically lines 7 to 17. Internal page 90, I make similar points as to why, as a case management decision, referring now, simply can't happen. or simply shouldn't happen, because we're not clear on exactly what it is that needs to be valued and the background circumstances. I then set out what we understood at the time to be these alternative approaches. Is what is being said that it's simply the contract price was simply much higher than market value, or is in fact there an issue about that price being paid for two separate things? And that's internal 92, 17, line 17 to 23. And the point that I make there is, on any view, the price agreed by parties at arm's length is often the best evidence of what actually is the market value. And if it's not the best evidence, for whatever reason in a particular case, on any view it is evidence of what is market value. So how can the Lands Chamber possibly do its job if it doesn't actually know the prior question of what the contract price was paid for, which is a matter of contract interpretation, which is not a Lands Chamber issue. Internal page 93 and 94. I reiterate, this is all very unsatisfactory, we don't know if it's been conceded. And I also raise at that point the issue of discovery assessments. And broadly, the reason the discovery assessments are relevant is as follows. A land transaction return is due for every notifiable transaction. In this case, we have 10 land transactions, one for each of the plot lease, so the acquisition of the leases. Inquiries were opened and closed and amendments made. But if actually the taxpayers are now arguing that 116 million is for two separate things, and that second thing is in fact also a land transaction, then what should have happened is the taxpayers should have filed a return for that land transaction. They haven't here, and the legislation tells us that HMRC, if there's a land transaction that's notifiable and no return is made, has 20 years to raise a discovery assessment. So we recognised at this point that depending on what actually the MPR option release argument was, maybe in fact we were missing a piece, which has then been covered off by the discovery assessments and those appeals. And just for your note, the discovery assessments are in, and the covering letter, supplementary bundle, 25 is the covering letter, tab 25, and 26 is the sample discovery assessment. And it's clear from that that there's no concession at all about exchange treatment to the extent that that's relevant. Now, pausing here.
Or to the extent it's relevant to the subject matter of the discovery assessment,
yes.
Which is the MPR
release. That analysis, exactly. Yes. So pausing here. Fast
So
forward.
that's just protecting yourselves if it's not an exempt transaction. If your case is that, well,
yes.
Even if it was two separate transactions, the MPR, you say, is a separate land transaction that wouldn't be exempt, and therefore they should have paid duty on that, or stamp duty on that too.
Exactly.
And
yes.
therefore you've filed a discovery, issued discovery assessments to cover that eventuality.
Exactly. That's exactly right. Yes. Pausing there, I think it is simply helpful to look at what the parties are now saying the issues are in the combined appeals. Now, I just want to note, this wasn't before the Upper Tribunal, so this only really matters if we get to the stage of the analysis where the Upper Tribunal's decision is set aside and this court remakes that decision. Where are we now? What actually are the pleaded issues? So if I could ask you please just to briefly turn up the taxpayers' further and better particulars to their grounds of appeal. So this is supplementary bundle, tab 35. And specifically, this starts on paragraph 33, which is page 295. And so you'll see that at paragraph 33, they set out their grounds of appeal in relation to the closure notice appeals, and in paragraph 34, they set out their grounds of appeal in relation to the discovery assessment appeals. And all I need to say about these is it's clear when you look at it that as at today's date, pure tax issues arise that need to be determined. We say they logically fall to be determined before market value. We also say that depending on precisely who wins in what issue, a possible outcome is that market value becomes irrelevant because the 116 was given for the land alone and there's no exchange and the first tier is allowed to decide that. Secondly, and this is really just a point in case management in terms of actually pinning down what the issues and the arguments are and how much the sand keeps shifting. You'll see if you look please at paragraph 34.6 and 7, you'll recall that I showed you Norton Rose's correspondence that referred to HMRC's suggestion that the consideration for the MPR release as nil was fanciful, but now part of the appellant's grounds of appeals are that the consideration for the MPR release is nil, and we just don't understand what's going on behind the scenes. And so I only show you that because there's clearly the issues are changing. If as a practical matter a referral is to be made, what exactly is being written into that referral as to what the issues are, what the positions are, what actually is going on. Thirdly, you'll also notice that in relation to the discovery assessments, the taxpayers now seem to be arguing that although it was the LG Park companies that paid the 116 million consideration, the release of the MPR option was not in fact of any benefit to them, and they are saying the release of the MPR option was not an exchange. And again, we struggle to follow the thread of all of this. So pausing there, not only is some of this in direct contrast to what we previously thought the case was, it also creates a real uncertainty as to how the contractual arrangements should actually fit together, and the underlying commercial deal. How is it supposed to fit together, and how are those contracts supposed to be interpreted? And we say those questions can't possibly be for the Lands Chamber to decide, not least because contractual interpretation is an issue of law, and that's not within the Lands Chamber's jurisdiction. And as a practical matter, what would the status be if everything went to the Lands Chamber now? They make determinations, it then comes back to the first tier. Are the first tier bound by factual decisions, interpretive questions? It just practically seems to us to be unworkable. And then the last point in this is our statement of case. So we sent this in 14th of November 2022 at post-date of the Upper Tribunal's decision, and it's our understanding as at today's date. That's behind supplementary bundle tab 36, and we have set out the issues pages 320 to 321, so paragraph 30 onwards. And what we've tried to do here is a slightly different approach to the taxpayers. They set out closure notice issues, discovery assessment issues. We've tried to combine the two to say, okay, taken in stages, what is it the first tier needs to determine now that these two appeals have been joined? And again, you'll see from this, there are a lot of issues other than market value, and market value is not the first issue. in either party's lists. So that's what I wanted to say about the background to the substantive dispute. I now more briefly just want to run through a couple of points in the procedural chronology, and if I could ask you just to have the amended chronology in front of you. So, just summarising the key events, the taxpayer's Para 45 application was lodged shortly after their appeals had been lodged, and before any statement of case, list of documents, statement of agreed facts, statement of issues, etc. That was the point in time, so none of that work had been done when the first tier heard and determined the Para 45 application. The taxpayers then appealed the first tier's refusal. At that point, 30th of July 2020, HMRC issued the discovery assessments, and 22nd of January 2021, the first tier appealed those to the first tier. Now, once the discovery appeals were live, we applied to the Upper Tribunal to stay the Para 45 appeal, because we said, well, actually, now that we've got discovery assessments, surely this is all redundant. The Upper Tribunal refused to stay it, and just for your note, that supplementary bundle, tab 27, PDF page 196, and I'll leave the court to read the reasoning given there. What then happened is the first tier directed the closure notice and discovery assessment appeals to be joined so that they could be case managed together. And it's perhaps useful to turn up the first tier's directions, which is supplementary bundle at tab 32, page 227, Judge Alexander.
You're going to the wrong place. Which tab should I be?
It should be tab 32 of the supplementary bundle, page 227.
Yeah.
277.
I'm sorry, 277. I misspoke. Thank you. And you'll see the reasons given over the page 278. The reasons for joining them are paragraph 1. The two appeals arise out of the same facts. And then just to note paragraphs 5 and 6, in terms of how the first tier tribunal has understood the appeals. Now, what we then have in the chronology is the Upper Tribunal allowing the taxpayer's appeal. And I'll obviously come back to the Upper Tribunal decision more fully in due course, but it's useful now just to see what they directed, which is core tab 7, page 96, and really it's paragraph 65 onwards. And just to summarise, because these passages will be familiar to the court, the direction was that market value and the closure notice appeals be referred to the Lands Chamber, and in all other respects, the closure notice appeals remain with the first tier. The discovery assessment appeals necessarily have to remain with the first tier because they weren't part of the appeal to the Upper Tribunal, so the Upper Tribunal has no jurisdiction over them. Paragraph 67 in particular over the page, is problematic because it sets out the expectation of the Upper Tribunal that the first tier should stay the two sets of appeals and make the referral and allow the Lands Chamber to get on with the process of valuation. And faced with all of that, at this point we decided that the most expeditious way forward was to appeal that decision. Now, further applications were then made to the first tier. What should the first tier do, given that this is now being appealed? The taxpayers wanted the closure notice and discovery assessment appeals to be stayed, so no further progress happened. We said, no, let's just get on with it. And the first tier agreed with HMRC, and it's useful to see again what Judge Alexander, who'd made the previous directions, said about this. So this is supplementary bundle, tab 28, page 199 onwards. So he summarises the applications in the preamble. Directions 1 to 3, he refuses the taxpayer's request to make the reference immediately because he agreed with us that if the Court of Appeal were to overturn the Upper Tribunal, then all of a sudden the Lands Chamber proceedings just are completely void. He also refused to stay the First-tier Tribunal proceedings, and he directed that the parties agree case management directions. And what is particularly relevant to where we are now is reasons 4 and 5. And these are the passages that we cited in our skeleton argument, where the first tier is saying, it appears to us that in making the decision to refer, the Upper Tribunal hadn't actually properly understood how little progress had been made. And importantly makes the point at 6, I consider that it would be very difficult to make a reference to the Lands Chamber on the valuation question in the absence of the statement of case. It is not possible, and on any basis not desirable, to establish the terms of the reference of the valuation issue in the absence of pleadings, etc. Just to summarise, and we say that's relevant to the Upper Tribunal's decision because actually what the Upper Tribunal directed was something that the first tier clearly found practically unworkable. Since then, the parties have actually made considerable progress in the FTT, and you'll see from the amendments to the chronology, the taxpayers served further and better particulars explaining their grounds, which we've just seen. We served a consolidated statement of case, and you've seen how the issues in that are set out. A statement of facts has been agreed, which isn't before the Court of Appeal, but is pretty short, because actually, other than these documents were entered into, there's not much agreement as to the underlying commercial deal. Witness statements have been served by both parties, listing information has been provided, and the hearing window currently is for autumn 2024. I don't actually know why it's autumn 2024, but that's where we are now.
Is that the sort of delays you'd anticipate there being?
I just can't tell you whether it was council's availability or quite what. I was personally quite surprised to see it was autumn 2024. I don't know the reason for that. I can see if I can find out if it's relevant.
And that I see is for a 4-day hearing where it's anticipated there will be cross-examination, presumably.
Of the witnesses of fact. So HMRC has a witness about discovery, the validity of the discovery assessments, and the taxpayer has, and forgive me, I can't remember offhand if it's 1 or 2, but 1 or 2 factual witnesses setting out the context and the commerciality of the deal. So the current situation is that these appeals are actually now ready to be heard, and the very next thing is a hearing, and literally nothing has happened in the Lands Chamber because no reference has been made. And that is relevant if we get to the stage through the waterfall of permutations of the Court of Appeal having to remake the decision based on where we are today.
And just you were referring us to the Upper Tribunal decision, the last part. So paragraph 70, they direct the question of the market value of the subject matter of the land transactions in the appeals.
Yes.
Um,
I'm sorry, one minute so I can. Paragraph 70, yes.
and the land transactions in the appeals are exclusively the letting as opposed to the release of the MPR.
Yes, that must be the case because it's only the letting that is subject of the closure notices, and the reference is only made under para 45 in relation to the closure notice appeals.
Yeah.
So that's not in relation to any market value reference in relation to the discovery assessment appeals, and nor could it be because there hasn't actually been an application for a reference in those appeals.
Well, and the UT didn't have the discovery assessments before
No.
it. I mean,
but
put wrongly, the scope of the appeal to the UT
exactly.
related to the closure notice.
Exactly. And pausing there, I've already set out my submissions on why actually market value might not be relevant at all. There's another point, which is depending on exactly what the tax issues are, you might end up with market value being relevant, both in relation to the land and now separately in relation to the discovery assessment subject matter, which is the MPR option. And the effect of the Upper Tribunal directions, which we say gets us into ingenious Upper Tribunal territory, just plainly wrong, is Lands Chamber is now to press ahead and decide the closure notice. Decide the market value of the plot leases. Then we're back to the First-tier Tribunal to decide legal issues. It is possible that the Lands Chamber will have to be called upon again at the end of that for a completely separate hearing, some time later, depending on how far these issues are appealed, to decide the completely separate issue of the market value, possibly, of the release of the MPR option.
And just pursuing that a moment longer, so at the point at which you get to the Lands Chamber on the value of the leases, you say, well, look at the leases, what's stated in them is very good evidence of the market value. The taxpayers say, no, because some of that money is being paid for other things. And at that point, you have to work out
what other things, which we say isn't a Lands Chamber matter at all, because that's issues of law, including contractual interpretation.
But in any event, just as a matter of valuation, insofar as the figures stated in the leases are relevant, you have to work out, or maybe the Lands Chamber would say, well, forget about the figures stated in the leases. But if you don't say that, you have to work out how far you discount those figures for the release of the MPR.
And to be perfectly blunt, if the Lands Chamber said, forget about the actual price paid, we would say, well, that's an error of law and we'll appeal that. So that, I mean, if you're going to disregard it altogether, that on any view is evidence. How good or bad it is may depend on the facts, but it can't be disregarded.
And certainly, if you do think it's evidence, to work out the significance of the evidence, you have to work out how much you might attribute to the MPR.
And round we go.
Exactly.
And that's exactly the point and exactly the difficulty and why it is we are still troubling the Court of Appeal with this position in circumstances where actually, in one view we may say, well, who really cares now the first tier has decided to ignore what the Upper Tribunal's directed anyway, put bluntly, although it's done that pending the decision of this court on appeal.
Yeah.
And just to finish that off, if we're only interested in contract price, and the contract price was paid for two things, then it's obvious that whichever way you slice it, 116 million is paid for those two things. Depending on whether or not both of those things are land transactions, we HMRC may not care about the niceties of how that 116 million is split, because on any view, we're getting SDLT on 116 million.
What you say is that if they're not two separate if they are two separate transactions, but the MPR is an exempt transaction, your point is that the Lands Tribunal would have to say, right, starting point 116, and no doubt the taxpayers would produce their valuers to say only worth 30 million. So what about the middle about the difference. And I think the HMRC says, well, hang on, you cannot have a land tribunal then deciding the issue as to whether the MPR is or is not a security interest. That's firmly a matter for the first-tier tribunal. And
I go on, if it is not a security interest, it isn't an interest in land, it isn't the subject matter of a land transaction. The Lands Chamber has no jurisdiction to value things that aren't land anyway. That there's one further point, which just, I think, elaborates on how complex
rise, enable.
Now, how are we doing?
Thank you. Good progress. So I'm now moving on, having finished with the chronology, to our submissions on para 45.
Yes.
If I could ask the court please to turn it up, it is Authorities Bundle, tab 10, page 23. And so obviously the court's familiar with this, where the question in any dispute on any appeal under para 35(1) is a question of market value of the subject matter of the land transaction, that question shall be determined on a reference by the relevant tribunal. Land transaction is defined as any acquisition of a chargeable interest, and that's section 43(1), which isn't in the bundle. And as we've already seen, a chargeable interest excludes an exempt interest, section 48(1). So how do we say para 45 should operate in principle? My first point I want to make is about the relevance of the word the, where the question in any dispute. So one interpretation of those opening words might be to say that the question of market value has to be the question, the only question, or the only question left. Now, it doesn't say where the only question is, but equally it doesn't say where a question or where one of the questions is. Taking this in stages, on a literal interpretation, we would say that if there are other non-market value questions, the para 45(1) condition isn't met. However, we can see that it's theoretically possible that cases might exist where a determination of market value should pragmatically be decided first, followed by tax issues. And it would be contrary to purpose if para 45 actively precluded that. So we say that on a purpose of construction, probably the better interpretation is it should theoretically be possible for a reference to the lands chamber to be made where a question of market value has been identified, even if it's not the only question.
And can I just ask about that? Suppose that your literal interpretation were right, so that this didn't apply where there were two issues. Would that mean that there was no jurisdiction to refer to the lands chamber?
Yes, and that's actually important for how I approach what the First-tier Tribunal has done, because if that is right, there is no jurisdiction. We're not interested in the niceties at that point of case management and the overriding objective. Overriding objective, whether it's pragmatic, cost-effective, etc., out the window, you just can't do it. And that's one of the reasons why we say that when you look at what the first tier did, it actually made two freestanding decisions. One, it said, which the Upper Tribunal decided was wrong, I can't refer if there are other issues. But then it said...
Well, I'm not sure the FTT did go that far.
Well,
there's a bit of a difference in language between different paragraphs.
Exactly, and your ladyship is exactly right, and I'll show you that when I go through the decision. But I will also show you that there is possibly one sentence where it could be said that that might be what the First-tier Tribunal did say.
But don't the Upper Tribunal point out that the case was effectively put on that basis?
Yes. But the Upper Tribunal says, well, that's wrong in law, so
okay,
too bad. Doesn't matter. We, the Upper Tribunal, are going to apply the law properly. Yes, so that is another complication. It is fair to say that the party's own understanding of para 45 has refined as the case has progressed. And so, yes, it's somewhat unjust to say the First-tier Tribunal got it hopelessly wrong, because actually that's the way the parties proceed. But the reality is, if the parties and the first tier were wrong about the legal interpretation of para 45, that's just the way it goes. So, and the Upper Tribunal would at that point have been right to step in. But the relevance of dealing with your lordship's point is overriding objective logically is only relevant to anything in circumstances where it's been accepted that the para 45 condition is met as a prior stage. And that's why we say that looked at logically, quite how you define the first tier's interpretation of para 45 on any view, what it says about case management and the overriding objective must be freestanding, because that can only be relevant if para 45 is engaged. It's got nothing to do with the interpretation of para 45 itself. So we do certainly say, and of course it's open for this court to say, well, actually, the way this court reads para 45, where the question means if it's the only question or the only question left, that isn't something that we're forcing on this court for the reasons I've explained.
I'd imagine you wouldn't welcome that interpretation. I mean, because you're going to have other cases where it could be convenient to refer a market value question.
Well, ironically, in thinking about this and preparing for this hearing, I tried to think of an example. I actually found it very difficult to think of an example. So I can't say to you, for example, here's a good example of where you might. So that's why I put it as, it might be theoretically possible that such a case arises. Actually, I found it quite difficult to think of one, because either there are prior tax questions, in which case, if they're questions of law or fact, well, why are we rushing off to valuation? Or there's some sort of question about, is a discovery assessment valid? Is a closure notice valid? Was the inquiry open in time? Why are we rushing off to valuation if there are those sorts of questions? Obviously, the first tier should deal with that first. So I couldn't actually come up with any good example as to why you would want to rush to valuation first if there are other issues.
I suppose one might be where it's obvious on the numbers that the valuation issue is the key issue, and it might then prove not necessary to hear other issues because agreement might be reached. That would be one example.
Possibly depending on who the appellants were, how things were split. Yes, but I certainly couldn't think of an actual hypothetical example to say, look, here is why actually we should interpret it more broadly. So all I would say is that is a possible interpretation. I think we're neutral about whether it's right or not, and we're certainly not pushing it on this court. So the second point then is what is para 45 actually doing? And we say that it's limited to doing two things. First of all, it tells us that questions of market value should be determined by the Lands Chamber. In other words, they shouldn't be determined by the first-tier tribunal. Secondly, it tells us that the method of getting a question of market value from one to the other is by the first tier making a reference, in inverted commas. Critically, para 45 says nothing at all about the timing of when the first tier should make a reference. And we say that it necessarily must follow that that timing point is left to the first tier's own case management discretion. The other point is that para 45 also gives no indication of what a reference should contain. And again, we say that should be a matter for the first tier's discretion, and that may well in turn influence the timing of when it's appropriate for the first tier to make a reference.
If you just educate the ignorant for a moment, is there sort of a fairly standard form of reference?
Not that I'm aware of. And so one of the submissions that the parties considered, certainly before the first tier, it may or may not have come up again in the Upper Tribunal hearing, I wasn't there, is maybe it's a bit like an ECJ reference. But as far as we are aware, there's no prescribed form that sets out what it should or shouldn't contain. And you can see that depending on the case, and here I was able to think of obvious examples, the contents of a reference might be very simple. So it might be, what is the market value in circumstances where properties are acquired by a connected company, one of the provisions tells you that the chargeable consideration is deemed market value. And there the reference could be short. What's the property? Well, everyone knows. What's the valuation date? Everyone knows. And why is it the first tier needs to know market value? Because that's what section 53 says. So over you go, Lands Chamber. That's a very short and neat reference. And now, critically, and we say this case is an example, the Upper Tribunal may require more detail, and it may require prior findings made by the first tier. And that is similar to when the first tier used to make references, or the tribunals, the courts used to make references to the CJEU. And there may also be quite prior questions, e.g. of law, contractual interpretation, say, that the first tier needs to answer before a reference can, I'd say sensibly be made, but one might even say can possibly be made, because it's not up to the Lands Chamber to determine other questions of law. Because para 45 also limits the Lands Chamber's jurisdiction to determining only the question of market value. And that point is important for the reasons I alluded to earlier. The Lands Chamber shouldn't be finding facts that are in dispute in the border tax appeal, and it also shouldn't be valuing anything other than the subject matter of land transactions. And if one of the prior questions is, well, what exactly are the land transactions here, you can't actually get to the stage of referring anything to the Lands Chamber until that prior question has been answered. Now, that's what I wanted to say about the principles behind para 45. How should para 45 apply here? So, taking ourselves back to the point in time where the first tier made its decision, all the first tier had was the appellant's brief grounds of appeal. There was a real dispute before it as to what those grounds of appeal actually meant. It had no facts, no issues, no nothing. One of the matters was clearly what had the 160 million been paid for, and we say it's not the Lands Chamber's job to find disputed facts about that underlying commercial deal or that contractual interpretation. That's the first tier's job, and we say that the fruits of that would feed into the reference to put the Upper Tribunal's job in context. I've already made the point, but here that's critically important, because if contract price is evidence of value, the Upper Tribunal needs to be told what that money was actually paid for. So what is that 116? What's it evidence of value of? And actually, I was going to set out submissions as to the possible permutations, but I covered that in my opening, so I'm not going to repeat myself. And there's also the question of whether market value is relevant at all, and whether it's relevant in addition in the discovery assessment appeals. And all of those, we say, are relevant to the proper case management. And the proper case management is not a question about how para 45 itself should be interpreted. That's left to the discretion of the tribunal. Now what I want to do is move on to the first tier's decision and make my submissions on why we say the first tier made no material error of law, emphasising the word material. So that, the first tier's decision is to be found in Core Article tab 11, page 115. And just for your note, I suspect this court will be very well versed in this, but in HMRC's skeleton argument, para 41, we refer to divorce in the Court of Appeal and why the question of materiality is relevant. Now, our submission, looking at the first tier decision, which I've already set out in my opening, is the first tier gave a self-standing reason, and that reason is the latter part of FTT 49, that it was consistent with the overriding objective not to refer the question of market value at the time the first-tier tribunal heard the appeal. Now, not only was that freestanding, it was obviously sensible, we say, but in any event, the Upper Tribunal didn't specifically identify case management and the first tier's application of the overriding objective as containing an error of law. Rather, what it did was it said the first tier made errors of law in its interpretation of para 45. But as I've already submitted, that's a separate matter. So how we see this is, do you satisfy the para 45 gateway, yes or no? If no, stop there. If yes, there's a separate question that arises as to timing. And that's all case management. So if I can just walk through the decision, please. Starting off then, if we can go, and I don't need to look at every paragraph in detail, but if I can just summarise what parts of the decision we're doing. So tab 11 in the bundle, go to PDF page 118, please. Paragraphs 18 through to 22. This sets out the taxpayer's submission, and those were that the first tier should determine the scope of the closure notices on, and therefore the scope of the appeals on that application. That determination will show the only issue is market value, as that's the only question it's important. It's appropriate to refer. We then.
So just to be clear, before the FTT, the taxpayer's argument was simply, this is the only issue.
Yes.
And that there wasn't anything else.
Yes, exactly.
Which is consistent with the respondent's notice.
Exactly. And our submissions, summarised at first tier 23, where para 45 is not satisfied, and this is because we were labouring under the impression, as were both parties and the tribunal, that para 45 is only met if it's the only issue left. And secondly, our standalone submission was a reference would have been a waste of time and money and not in accordance with the overriding objective. I've already explained why that's a freestanding submission. So that was one of our two objections.
Sorry, where do you raise that as a self-standing point? Oh,
it's para
right, okay.
23,
last part.
which is the first tier's summary of our objections. And I say that second part, for the reasons I've already explained, necessarily has to be freestanding, just as a matter of logic.
Thank you.
Start of para 24. I think that's a typo. It should read Miss McCarthy. We say, and this is important when you look at what the Upper Tribunal in particular did with this and the respondent's notice, determining the scope of the closure notice shouldn't be addressed at that application hearing on any view, and we give our reasons. 25 to 26 captures my submissions about the lack of clarity of the taxpayer's ground of appeal and the lack of concession. Now, para 28, and this we start to get into the question of, well, exactly what words did the first tier use? Because it has described certain approaches in relation to para 45 slightly differently. So taking it in stages, we say para 28 paraphrases para 45 correctly. Sorry, that's too many paras. It identifies the question correctly as to whether it is appropriate to make a reference. And it considers that under two headings. What are the questions in dispute and what's the overriding objective? And that process also mirrors the way in which we had addressed our submissions. 29 and following sets out the parties' submissions about the issues. Para 32 sets out the first tier's summary of the correspondence. Para 33 sets out the narrower proposition put forward by the taxpayers about the scope of the closure notices. Para 34 sets out our submissions. A, as to the fact that the first tier shouldn't get into this. but on any view, we say the conclusion was a broader matter. Para 35 sets out the shift in terms of what had previously been the taxpayer's position on case management, and quotes from some of the letters. Now, moving on to first tier paragraph 36, and taking this in stages, I've concluded that in order to decide whether it is appropriate to make a reference, I should consider whether the appeals raise questions that should be decided before the remaining question of market value can be referred. There's no error of law in that part, because that's simply talking about a propriety of timing. This is not the same question as identifying the scope of the appeals. Now, pausing there, I wonder if this is a typing correction, and what the tribunal meant to say is this is not the same question as identifying the scope of the closure notices.
That's the way I read it.
Yeah, that to my mind
As did I.
makes more sense. So I
Yes.
think that's a typing error, and if my learned friend disagrees, he can explain that. And I think that's quite important when we look at what the first tier actually was doing. The reason I say that's an error is because the judge immediately goes on to refer to scope of the closure notice case law. That, therefore, is a correct statement. So moving on then to first tier tribunal paragraph 37, the first tier asks itself, have the taxpayers raised prior questions in their appeal notices that should be determined first before it's appropriate to refer? Now, pausing there, that is an obviously correct statement. The Upper Tribunal says, no, the focus shouldn't have been on the appeal notices, it should have been on the closure notices. But that's wrong for two reasons. One, the first tier decides that it's not actually going to address the scope of the closure notice question. And two, it's easy to think of all sorts of things that won't appear in a closure notice, but might legitimately be grounds of appeal. The most obvious one being, well, hang on a second, this is all very interesting, but HMRC didn't open your inquiry in time, so why are we here? You're not going to find that in a closure notice, you are going to find it in a notice of appeal. And if you think about it similarly in terms of discovery assessments, discovery assessment can only be made if certain conditions are met. That may or may not be canvassed in the discovery assessment, but obviously it's going to be in an appeal notice. So we say there's nothing wrong with that approach. Moving on to first tier 38, the first tier looked at the grounds of appeal first.
Sorry, just before we do,
Yes.
I just couldn't completely follow the last part of 37, but it may not be material.
Let me remind myself. Not addressing.
I don't think it
I have to say I certainly haven't identified it to make submissions on, and reading it now, I'm not sure I can entirely follow it. But on any view, that seems simply to be something the first tier has chosen not to do, and given that it's our submission, first tier hasn't addressed it, I have no problem with that.
Okay, thank you.
Moving on then to first tier 38. The first tier looked at the grounds of appeal first, quite right, nothing wrong with that for the reasons I've just given. First tier 39 is important. The first tier agrees with my submissions on the inadequacy of the grounds of appeal, in particular para 6b. That is important context to the case management decision. Is now the right time to refer? And there's nothing wrong with that either. First tier 39 to 40, the first tier summarises the taxpayer's explanations and the first tier's understanding of them, and that will coincide with the piece of the transcript that I invited the court to read that's in the supplementary bundle. Now, first tier 41 is important because the result of the prior consideration is that here the first tier is setting out its conclusion that it is concluded there is more than one question for the first tier, namely the subject matter of the land transactions for which chargeable consideration was given. Now, first of all, the tribunal says these are questions of both fact and law to be addressed by the first tier before a referral can be made. It's not clear whether first tier means before I'm permitted by the scope of para 45 to refer, or before a referral can be made in real life because I need to know what I'm writing in the reference notice. But that doesn't really matter, the toss-up between these two, because the first tier then goes on to say, even if these were not questions that prevented the reference under the terms of para 45, so the first tier here is considering an alternative approach, and that goes to materiality, it is difficult to envisage how the Lands Chamber could consider the market value without the prior tax law determination of the subject matter of the land transaction for which the chargeable consideration is to be determined for SDLT purposes. Now, that must on any view be right. More than that, that is focused on the practicalities, the case management, what is the first tier supposed to write in the reference. The Lands Chamber needs to know the subject matter and also how much of the contract price was paid for it before it can make findings about market value. And for all the reasons and all the explanation I've given before our short break, there's nothing wrong with that. Moving on then to first tier 42, having decided that there is this question about the subject matter that needs to be determined before a reference can be made, the first tier also specifically declines to decide the scope of the closure notice matter now. That is key because, one, the Upper Tribunal held that it wasn't unreasonable, that course of action wasn't unreasonable. Having declined to decide that issue, there's necessarily a second tax issue before the first tier, which is what is the scope of the closure notices. That is highly relevant to everything, because if HMRC is right, that opens the door to the exchange argument. And as I've already explained at the outset, looking only at the closure notice appeals, if there's no exchange, then market value just isn't an issue. And any reference to the market to the Lands Chamber now to determine market value has been completely for nothing.
Just reverting briefly to the first sentence.
Of paragraph 42.
Of paragraph 42. At least one other question before it would be appropriate to refer. And I suppose appropriate is ambiguous. It could mean before it's permissible, or it could mean in all the circumstances not a good idea.
I would say the latter, and certainly the way that we interpret the word appropriate is it isn't hard-edged. It is talking about the case management,
and there are other
discretion and timing.
And
exactly, my lady is quite right. There are quite a few references to what is appropriate throughout the decision.
Because you say this has all been conducted under the pragmatic approach to a substantial case management decision.
Exactly, and that's the beginning and end of it. Now we say separately, you can tell it's separate, not least because there's a separate heading. At paragraph 43 onwards, the first tier goes on to consider the overriding objective as a standalone piece. I'm just going through briefly the paragraphs. Para 43, we say there's obviously no error in this statement. It's quite right that the application is made under a specific statutory provision. Now, if we are right that para 45 is silent about timing and that's purely a matter of case management for the first tier's discretion, then here the first tier is entirely right to say that this should be considered applying the overriding objective. Of course it should. So 43 has no error. 44 summarises how the taxpayer sees the reference progressing. 45 sets out our objections. These are the Lands Chamber needs to know what it's valuing, and also raises the point about the discovery assessments they need to be made. Now, 46, I will say, is a little compressed. And this is the point where we can see that possibly on its face it might be said that there's a misstatement about para 45. And that is where the FTT says, this does not sit comfortably with the wording in para 45 that suggests that the question in dispute shall be determined on a reference, as the reference will not determine the questions in dispute as far as HMRC are concerned. Now, as I say, it's a little ambiguous, it's a little unclear. There's a flavour here that somehow it was the reference of the whole appeal. It's unclear. And obviously, if this is a statement about referring the whole appeal, that clearly is incorrect because that's not what para 45 is doing. But we also say, for the reasons I'll come on to, that's actually neither here nor there, because it didn't affect the tribunal's overall case management decision. Then the following sentence in First-tier Tribunal, paragraph 46, what will arise if Mr. Baldry's submissions are accepted is simply the first tier setting out the hypothetical. If Mr. Baldry is right, then what Mr. Baldry says is right, which doesn't tell us anything at all. 47 and 48 quotes from Investec. Now 49 is important. The first part, I've concluded above that the conditions for making a reference under 45 are not satisfied. Pausing there, if this court decides that market value doesn't need to be the only issue left, arguably there is an error in that statement, because it's quite difficult to understand what the conditions for making a reference are, unless, and this links back to the previous wording, what the first tier here is talking about is it's not possible to identify the land transaction that should be referred. So in context, 49 is ambiguous, slightly unclear. On its face, it may look like there's an error. But we say that's actually neither here nor there when you go on to read. But this decision is confirmed by having regard to the first tier's duties, including the duty to further the overriding objective when considering the circumstances of the application. And for the reasons I've already set out, you only get to the overriding objective if you've already decided there's something to refer and the conditions are met. It's consistent with this reading of para 45 and then this wording that I am not required to refer the question of market value where there are still questions, etc. And that is absolutely right, because 45 is silent about timing. The first tier isn't required by para 45 to refer.
And just reverting to the earlier discussion, if here the FTT is considering the overriding objective and what's a good idea, why in, say, paragraph 42 is it talking about what would be appropriate unless it means permissible?
So I think perhaps we're slightly at cross purposes, my lord. So I interpret appropriate as being what is appropriate to do as a matter of case management. Not...
In which case, why is it dealing with it in paragraph 42 rather than in the overriding objective section?
Having reached a conclusion. I think at that point I say we'll read the decision as a whole, which, you know, one might say, well, there are two points. The first point is actually when you read that section as a whole, it's a good reason for saying that the first tier did not fall into the hard-edged error that the Upper Tribunal identified. I can only refer if it's the only question. So actually that at 42 is evidence that the first tier didn't make that error. And the second point is it's just loose language. But certainly when you look at what is said about the overriding objective and think logically about the circumstances in which the overriding objective only becomes relevant, that's why we say that it's...
So on any view you say, well, that's a distinct point.
Yes.
Case management is a distinct point.
Yes.
I suppose in any event there is no clear statement in in the FTT decision to the effect that you can only refer if.
I'm sorry,
There is at least no clear statement in the FTT decision that it is only possible to refer
exactly.
if, rather than most of the statements are
Exactly.
either ambiguous or suggest that a case management approach.
Now, one might say in context, well, that actually is how you should read the first tier's decision because that's what the parties were telling the first tier. And what I don't want
to be clear, they were telling the first tier that it has to be the last point.
Possibly it's slightly more nuanced than that because the application was only made in the first place on the footing that market value was the last point.
Was the only point.
Sorry, was the only point. And the first tier was invited to decide it was the only point. And having made that decision, then the application to refer was being pursued. And I think I'm right in saying that if the first tier decided against the taxpayers on that point, then the application wasn't being pursued because it was accepted by the taxpayer, rightly or wrongly, that at that moment in time an application either couldn't be made or shouldn't be made.
Okay, so really the correct construction of paragraph 45 didn't arise for
certainly we would say that when you read the decision, there is no clearly wrong statement about para 45. But I suppose what I didn't want to do is get into an argument about the precise words used and the language and so on and so forth, because I say none of that actually matters because we have the freestanding, the easy shortcut, which is the freestanding overriding objective point. And so actually, irrespective of precisely what the first tier did or didn't do on para 45, if it made an error of law, it can't be material, which is the relevant criteria, because overriding objective.
Just before leaving this, paragraph 49 of Mr. Baldry's skeleton.
Sorry, one moment. Para 49.
Yes.
Mm-hmm.
Where he says something on this subject. Do you disagree with any of that?
Sorry, one moment, please. Where was it? I would need to go back and check. I just can't remember exactly how the skeletons were worded.
And you yourself weren't involved at the time?
Well, I was involved before the first year.
I see, yes.
So I just can't comment on that. I would have to check. But what I do say is correct is that, as we understood it, the application for a reference was only made in the first place if market value was the only issue. So it's not quite right to say that's why we opposed it, because that was the footing on which the application itself was made anyway. So there was nothing to oppose. But certainly, this is from memory only, that does seem to accord with the slight misapprehension that the parties were labouring under at the time. And our understanding, both parties' understanding of para 45 has refined since then. So just returning back to the first tier's decision, and I think we were looking at para 49. Yes, so that only leaves me to, and you already have my submissions on para 49 and the self-standing point and why that logically must be correct. Moving on then to the conclusions at para 50. Sentence 1, I've concluded that the questions in the substantive appeals are not limited to market value of the subject matter of the land transaction. Pausing there, on any view that's right, because on any view, the scope of the closure notices is now an issue, because the first tier has Questions of tax law relating to the subject matter of the land transactions, for which the chargeable consideration is to be determined, must be decided by the first tier before the valuation can be referred. In context, we say that this sentence is not some hard-edged, I have to do these steps before I have Power 45 jurisdiction. It's simply saying, in this appeal, I need to do one thing before I can refer the second thing. And then the application for the referral does not satisfy the conditions of Power 45, query whether that's right or wrong, but on any view, or meet the requirements of the overriding objective, a freestanding point, no material error of law. And one thing that might be useful just to look at is what the Upper Tribunal said in its permission decision about this ground. So I appreciate I'm taking this slightly out of order. But this is Core Bundle tab 8, and the relevant page is page 100, and under the heading Ground 1. And in short, with respect to the Upper Tribunal, you'll see the Upper Tribunal just misunderstood the argument. So 5, Ground 1, this asserts that the first tier made no material error of law because it also decided that its conclusion was consistent with the overriding objective. Then 6, reference to the overriding objective cannot have the effect of curing or negating a material error of law. But that absolutely isn't the point that we're making. That's simply a misunderstanding of the argument. And so I don't put it any higher than this. It may or may not be an indication of what went wrong in the Upper Tribunal when looking at this.
So you were saying it wasn't a material error, so there's no question of negating a material error. It wasn't a material error.
Exactly right. And it just shows that the Upper Tribunal just didn't understand what was being said about how the first tier's decision was set out. And it says an HMRC didn't raise the point. Well, it obviously didn't, because that's not the point we're raising even now. So pausing there, if the Court of Appeal is with me on everything, then analytically we can stop. No material error of law, first tier decision should be reinstated. If, however, for some reason as yet unidentified, the court does decide that there is some material error of law in the decision, we now have to ask, looking at the Upper Tribunal's decision, did it make a material error of law? And we say that it did. It made various material errors of law, and I'll address in particular what it said about the interpretation of Para 45, because I recognise on any view that's something important that the Court of Appeal will likely wish to consider in its judgment. That's the important point of principle, the reason we're here. So the Upper Tribunal decision is Core Bundle tab 7, starts on PDF 80. And so just scrolling through paragraph 3, the background, 40 federal legislation, 11 to 17, paragraphs 11 to 17, summary of the first tier's decision. Now, just a reminder in terms of chronology, paragraph 18, now the discovery assessments have been issued, and we accept, and paragraph 18 and 19 are correct summaries. We also say there's nothing wrong with the Upper Tribunal's approach to its jurisdiction, which it set out at 20 to 22. Now, moving on to 23 to 27, relevance of questions other than valuation. We accept what is a pretty uncontroversial statement at 23. We just note Upper Tribunal 25, and I think this is the point I made earlier in response to one of my questions. The basis on which the taxpayers were pursuing their application is they weren't asking for a referral if there were other matters in the closure notice appeals to be determined. So that was the basis of their application. It wasn't really a matter for us to object or not to a legal proposition, which just wasn't being pursued. Now, Upper Tribunal 27, we say, conflates two separate matters, and this is where the Upper Tribunal starts to go wrong. It conflates what the wording of Para 45 requires with the separate question of case management and when the referral should be made in any given appeal.
Sorry, can you, just going back to clarify on 25.
Yes.
When you say you took, you're objecting to the took no issue, you're saying that because the application was made on that particular basis, you didn't really need to get into.
Exactly.
Right.
Exactly.
Sorry. Would you mind then just repeating what you were saying on 26? My benefit, apologies.
No, not at all. So I said nothing about 26, I think, but it was 27. So 27, we say the Upper Tribunal conflates two separate matters. And it's important to recognise that because that conflation starts to infect the rest of the Upper Tribunal's decision. So it conflates, on the one hand, what the wording of Para 45 requires, with, on the other hand, the separate question of case management, in particular, when a referral should be made in any given appeal.
I must say I haven't understood paragraph 27 because this is being relied on in support of the idea that the FTT thought that it could only refer if value was the only question, as I understand it. Or have I misunderstood it? Because 23, they say, there's nothing in paragraph 44 that says that a reference can only be made where it's the only question. Then they say the FTT nevertheless approached it on that basis. So they have to be approaching it on the basis that they can only refer if it's the only question. And then they say, we think that's how the FTT approached it for three reasons, of which the third is that they considered the overriding objective. But consideration of the overriding objective on the face of it points in the other direction. Exactly. So I'm not quite sure what the Upper Tribunal was saying there.
And so we would be inclined to agree with that, but what we think is being said, and this is where the error starts to creep in, is it's actually muddling up two things. It's starting to suggest that the overriding objective has a bearing on, or certainly that is how the Upper Tribunal interpreted the first tier as approaching matters. Overriding objective has a bearing on the hard-edged question of what does 45 mean. It may be that this is slightly academic, but we don't, I mean, yes. I suppose the point is, we say as we read it, 27 is where things start to go a bit wrong in terms of understanding what the first tier actually did and in terms of the analysis. And the second point you'll see more clearly as we go through the decision. So 28, taxpayers' grounds of appeal. Upper Tribunal paragraph 29 is important, and if I could just ask the court to just take a quick moment to reread that. And pausing there, we would say that that is possibly a reasonable analysis of what the appellants, the taxpayers' grounds of appeal were, but actually these just aren't the right questions for deciding whether or not it's appropriate to make a reference. But the other point I'd make is the way that the Upper Tribunal describes it at para 29, my paraphrase, if the first tier was right in concluding that there were other non-market value questions in the appeals, then it wouldn't have been appropriate to grant the reference. And so here, the Upper Tribunal is supposedly setting out its role as being something more limited. Well, that's the only thing we have to decide because the reference isn't being pursued otherwise. But what we'll see is the Upper Tribunal goes on to make far broader determinations than simply that question. Now, 30 to 34 is important. Here, the Upper Tribunal considers the taxpayer's ground that the first tier erred by refusing to determine the scope of the closure notices. And the critical decision on this point is at 34. So the Upper Tribunal says, and I paraphrase, well, we might have been inclined to decide the scope of the closure notice issue. But when you get to 34, the Upper Tribunal has concluded the first tier didn't make an error of law in refusing to decide that issue. Now, pausing there, that is important because the consequence of that decision alone necessarily means the Upper Tribunal has gone elsewhere. It's gone wrong elsewhere. That conclusion means that there is an issue before the first tier as to the scope of the closure notice. And for the reasons I've already explained, depending on how that issue and subsequent issues are determined, the upshot of that issue being properly left for the first tier is that there is one outcome, which is market value may not arise at all. And that directly flows from that decision that the Upper Tribunal is not interfering with the first tier's refusal. And that being so, we would submit that whatever the subsequent reasons, the decision of the Upper Tribunal that it's appropriate to refer now must be plainly wrong on ingenious grounds. It just can't be a pragmatic case management outcome. Now, moving on to 35, it wasn't, I just note this, it wasn't entirely clear to us what the Upper Tribunal is referring to here when it talks about the alternative approach, the first tier's alternative approach. I'm not sure anything turns on that. 36 introduces a brief consideration of the purpose and construction of para 45. We have no issue with the opening observations at 37 to 38. At 39 to 43, the Upper Tribunal sets out what it says are 4 principles about the interpretive approach to para 45. We take no issue with the first 3, so that's paragraphs 40 to 42, which we say on any view are pretty bland statements of the obvious. Now, para 43, so far as the Upper Tribunal says para 45 is silent about when a reference should be made, that's obviously right, I agree with that. But, and importantly, it is wrong to say that the determination of the timing question must be guided by the 3 preceding points.
I mean, you put it that way. You might alternatively say, well, the 3 preceding points don't give any guidance.
Yes.
And if they gave guidance, then you'd have to be guided by them, but I'm not sure how they can give any guidance.
Exactly. And they can't give any guidance because timing is case management. Timing has nothing to do with the interpretation of para 45.
It's really more that 40, 41, 42 are given the parameters against which you'll decide whether when it's appropriate.
And it's a statement of the obvious that the Upper Tribunal can't make a reference before it is seized of an appeal, but that doesn't give any real indication about the timing consideration and the case management considerations, and nor can it. And so in error of law terms, we would say that 43, the statement at the end, is wrong because it takes account of potentially irrelevant factors or factors that are actually non-factors. And it disregards relevant factors, namely the first tier's case management discretion and the overriding objective.
Well, you might say that what the 4th point should read is overriding objective, rather than the fourth. Yes, the first three set out the ground rules,
Yes.
if you like.
In fact, it has to be guided by the overriding objective.
But beyond that, that is the principle that the FTT should be applying.
When you say you simply mean the overriding objective.
Yes,
Yes,
the overriding
exactly.
objective.
Exactly. But that also would delineate what the FTT was in fact doing and how the Upper Tribunal should have approached the decision by saying there are issues about the scope of Para 45, then there is the self-standing separate question about case management and overriding objective. Now, moving on to Upper Tribunal paragraph 43.
So just sticking with 43 for a moment.
Yes, of course.
Because what it seems to me is 43 actually doesn't give you any guidance at all. Because,
Yes, I'd be happy to accept that.
and the guidance, as my lady, Lady Justice Falk says, that you say would be appropriate is to say, well, the guidance is the overriding objective.
Exactly. Which is different to A, what is said there, and B, how the Upper Tribunal goes on to apply these four principles. So moving on to Upper Tribunal 44, the first sentence is potentially correct. Para 45 doesn't mandate all other issues to have been determined first. You've had my submissions on that. Now the second sentence, we simply don't understand where this has come from, and we say it's plainly wrong. It's for HMRC to satisfy the first-tier tribunal that there are in fact material issues other than valuation within the scope of the appeal. And so our reasons as to why we say this can't possibly be right, where does this come from in terms of Para 45 itself? Secondly, it reverses the burden of proof for no explicable reason. It should be for the applicant to make its application good, not for the respondent to bear the burden of showing that there are other issues.
I mean, that all feels a bit unreal because when you're making a case management decision, burdens of proof don't really sort of come into it.
But as you'll see here, it very much was the guiding principle of the Upper Tribunal, and we say wrongly for exactly the reason you've articulated, my lord, because the Upper Tribunal says, well, we failed to be persuaded by HMRC that there are other issues on top of market value, and so there we are. Which may or may not be the same as saying that the taxpayer has satisfied us that market value is the only issue, which the taxpayer can't have done in circumstances where the scope of a closure notice point has been parked. On any view, pragmatically, how is anyone supposed to discharge this burden when the application has been made so prematurely? There's no statement of case, statement of facts, statement of issues, etc. None of that exists, so it's unworkable. Fourthly, it takes no account of, at this premature stage, how the first tier in real practical terms is actually supposed to draft the reference. And we say it's a material error of law, A, because it's legally wrong, and B, because on any view, it's wrong for practical reasons, and it's wrong in terms of market value as the only issue left, in circumstances where the scope of the closure notice is an issue left. Now, that error is emphasised, if you like, by the third and fourth sentences in Para 44, starting to approach matters otherwise. As I hope the court has appreciated, this isn't a case about hoping some other issue may emerge. It's about an inability to draft proper terms of reference and sensible case management. It's also wrong to say, well, this can't possibly be allowed to happen because the first tier would retain control for an indefinite period over an issue as to which it has jurisdiction. I mean, that, with respect to the Upper Tribunal, is a statement that is plainly wrong, because I've already set out exactly if and when a market value reference would be made. And the last...
So just unpacking it a bit. I mean, if it were indeed the case that the only issue was clearly market value. The FTT could not decide that, so I dare say it would be wrong for the FTT to keep the issue.
Yes.
But if there are things for the FTT to decide, which the Lands Chamber would have no jurisdiction to decide, it's hard to see how it's contrary to principle for the FTT to keep them.
And the point about an indefinite period, I simply don't understand, because the only reason we haven't actually had a substantive FTT appeal by now is because of these satellite proceedings, because the notices of appeal went in many years ago. And the last sentence is plainly wrong, and this is a material error of law, because the Upper Tribunal has just misunderstood how the issues might play out. The Upper Tribunal says the transfer must be made at some stage, and for the reasons I've already explained, that is not necessarily the case. Market value can, depending on the rest of the determination, fall away entirely. So actually, that last sentence, without more, is a material error of law in the Upper Tribunal's decision, because it's just failed to understand the issues and the evolution of the dispute.
Well, it's also at least the first part of it seems to make an assumption about the scope of the appeal.
It's the appeal which engages paragraph 45 and frames the questions,
Yeah.
yes. And my lady, you're quite right, and that may well be what the first tier had in mind when it said in its later case management directions. We think the Upper Tribunal didn't appreciate how little progress had been made.
So in fact, that sentence that my Lord Justice Newey was referring to, in the meantime, the FTT would retain control for an indefinite period. The answer is the FTT should and would retain control for such period as was necessary in order to determine
Exactly.
the scope of the closure notice and of the appeal.
Which the FTT has decided for case management reasons it's appropriate to do. Yes, exactly. Now 45 to 48, the Upper Tribunal here sets out further discussion about the scope of the closure notices. But that's all irrelevant, because it restates at 48 we aren't determining the scope of the closure notice in this appeal. Now, Upper Tribunal 49, we say, contains another material error which feeds off the preceding errors. It was not a sufficient ground to refuse the application that the first tier might decide in the substantive hearing to determine issues other than valuation. And I don't really understand how this has come about, because it's not a matter of the first tier of its own accord suddenly coming to the view in the hearing that it's going to decide all these other issues. The parties have now framed the issues, and the issues clearly include numerous other things on top of market value.
Yes, just reverting to the end of 48 as well, having decided not to determine the scope of the closure notices, they seem to be, the Upper Tribunal seem to be going back to that very point.
Exactly. Now I understand from the transcript that the Upper Tribunal, a lot of that hearing was actually focused on what is now the respondent's notice point, and so that may be why the Upper Tribunal distracted itself by being interested in that. But having decided it just wasn't going to decide the issue, all the rest of that debate is irrelevant. UT50 also contains material errors. Disagreement about the scope of the closure notice was a sufficient ground for the first tier to say we're not referring now, once you understand that one of the possible outcomes renders market value irrelevant. The first tier is wrong to say, and it's another material error, that market value was front and centre of the closure notice appeal. HMRC did identify specific additional questions, but on any view, as I've said, it's not for the revenue to prove anything. And also the point comes into play when the FTT had to make its decision, so little progress had been made. Moving on then to Upper Tribunal 50 and 51. At 51, the Upper Tribunal summarised the first tier's handling of our submission about the notice of appeal raising other issues. Now at 52, the Upper Tribunal sets out its reasons as why the first tier erred. And its first reason is illogical. Its first reason is the first tier effectively gave no weight to the terms of the conclusion of the closure notice. Well, pausing there, having decided it wasn't going to determine the scope of the closure notice, the first tier was absolutely right to give no weight to what was set out in the closure notice. That isn't a basis on which to set aside the first tier's decision. The second reason, in concluding that a disagreement as to apportionment was a question in the appeal, which raised the need for a prior tax law determination, the FTT frustrated the purpose and objectives of Para 45. We say, first of all, I say I'm not sure I actually understand the reasoning behind that. Secondly, if this is harking back to the 4 principles that we've already seen, the guiding principles about Para 45, it's wrong because what it's done is it's conflated Para 45 interpretation of a separate question of case management.
I mean, they seem to be proceeding on the basis that it follows from paragraph 45 that there is at least a presumption that you refer at the start.
Yes.
Now, if that is their reading of paragraph 45, you say it's wrong.
I say it's plainly wrong. And I also say that can't be the legislative intent, because why is it appropriate to trouble the Lands Chamber with anything in circumstances where the Lands Chamber may not be called upon? And even if one might say, oh, but send the reference to the Lands Chamber, and the first thing you HMRC can do is make an application to the Lands Chamber to stay it. You know, why are we troubling the Lands Chamber with this whole debate? It should only be appropriate as a matter of case management to refer if at the same time the first tier genuinely wants the Lands Chamber to go on and decide it. Because otherwise we're troubling, we're taking up scarce tribunal resource over this satellite litigation. And so if anything, looked at from that perspective, the guiding principle should be refer if you want the Lands Chamber to get on with it now. Otherwise, it's premature. And then lastly, the third reason given by the Upper Tribunal, any issue as to apportionment could most appropriately be determined by the Lands Chamber as an aspect of determining the value of the plot leases. Now, I've already explained why this is wrong, and I'm not going to repeat my submissions. There's also a separate point, which is what happens if, in fact, the plot lease market value is determined. Then we have years of first-tier squabbling about the legal issues. Now, all of a sudden, at the end of that, it becomes apparent that the Upper Tribunal needs to determine the market value of the MPR option release. That, on any view, is not efficient, suitable progress, because the Lands Chamber has now duplicated 2 sets of proceedings about essentially the same facts and circumstances. And the last point I want to touch on very briefly is support for this idea that the Lands Chamber can determine apportionment comes from this case called Denning that the first tier refers to at paragraph 53. Now, Denning is in the authorities bundle. It's authorities bundle tab 20. And the Upper Tribunal's reference to Denning, it is slightly unfortunate for 2 reasons. The first reason is that Denning Upper Tribunal was in fact overturned by the Court of Appeal. So the point about the Upper Tribunal apportioning between 2 things, the Court of Appeal has said it was wrong to do. This is the Court of Appeal's judgment. But on any view, and I'd be grateful if perhaps the court might just consider the head note over the short adjournment. But if I can just very briefly set out what the issue in Denning was. A question about the market value of leaseholds had been referred to the Upper Tribunal Lands Chamber. The Upper Tribunal Lands Chamber then got to the job of valuation. The methodology that the parties agreed was the right methodology was Royal Institution of Chartered Surveyors, something called VPGA 4, so that's in the RICS handbook, VPGA 4. That is all about valuation practice guidance, and that sets out the methodology on how to value individual trade-related properties. And this is a massive overgeneralisation, but the nub of the issue before the Court of Appeal was, did that computation produce a value for market value of leasehold, or did that computation produce a number that was market value of leasehold and market value of goodwill? So the relevant apportionment issue that the Upper Tribunal has confused itself in Denning, you can see in Denning, it's right for the Lands Chamber to decide, because it's all about what does the RICS methodology give you. You absolutely can't imagine the first tier having a go at that question, but that's just completely different to the issue here, which are prior fact-finding into contractual interpretation stages. So on any view, Denning just can't give the Upper Tribunal here authority for the proposition that the Lands Chamber here is the right place to determine the apportionment and attribution questions that have arisen in this case. And that's a very generalised summary of what was a very complex issue in Denning. So moving on then, back to the Upper Tribunal's decision. 53 then is wrong. And if I can summarise what goes wrong in the disposition, so that's Upper Tribunal paragraphs 55 onwards. 55 is wrong, the first tier didn't make material errors of law. As for Upper Tribunal 56, even if it did, we say the Upper Tribunal made material errors in remaking the decision. Failing to appreciate the early stage in the proceedings at the time the first tier had to decide the application. Failing to appreciate fully the full impact of the discovery assessment appeals. Misunderstanding that market value was front and centre, and in particular, paragraph 67, where the Upper Tribunal says a resolution of the land transactions would in fact bring greater certainty to an issue relevant to both sets of appeals. That's clearly wrong, because if the discovery assessment appeals has land transactions, A, we don't know if it does, and B, if it does, that isn't the thing being referred to the Lands Chamber on any view.
Sorry, which paragraph is that?
I'm looking at Upper Tribunal paragraph 67.
Thank you.
Just over the page, top of the page 97. Because that is suggesting wrongly that resolving market value in the closure notice appeals in relation to the plot leases should bring greater certainty to an issue relevant to both sets, which isn't right, because it misunderstands what the land transaction that is the subject of the discovery assessment appeals might be, and it's not the same. Upper Tribunal 68 repeats the error that valuation must be determined. And I think that I've made my submissions as to why, therefore, the overall disposition is just wrong. Now, what I want to do in the 10 minutes before...
So just before you do, if we got this far, you say, well, the Upper Tribunal's decision is vitiated. So we would have to make our own decision?
Yes, so sorry, I should have just gone back to that. My lord, that's exactly right. If the Upper Tribunal decision is set aside, then the options under the TCA for this court are remake or remit. I think that we might not want to start the process again by remitting. So what I would suggest is the right approach is, if this court is going to remake, it should remake the decision on the basis of the circumstances that exist today, the date on which the Court of Appeal is remaking the decision. And those circumstances are the subsequent progress of the joined closure notice and discovery assessment appeals, which is important because now the question is, are you just going to let the first tier get on and hear the appeals, that being the next stage, or are we going to park all of that progress and are we going to start brand new proceedings in the Upper Tribunal Lands Chamber? And I've already explained why, on any view, that might possibly be a waste of the Lands Chamber's time, and there are prior issues and so on.
But in any event, you say there was no material error of law from the first-tier tribunal, heavily underlining the word material,
exactly.
and therefore we should simply reinstate that.
Exactly.
So your primary case is there would be no need for this court in any event to remake, notwithstanding the multiple errors of law you say that the Upper Tribunal made.
Exactly, and that's the point of the waterfall in which I've made my submissions. Yes. So the very last point that I want to get onto, which I can cover off just before the short adjournment, is the respondent's notice.
Yes.
And you'll have seen that is core bundle, tab 3, page 54. The way in which that is framed, and actually it may be useful just to turn up if I could please. So core tab 3, page 54. The directions would be upheld for the additional reason that the scope of the appellant's substantive appeals against the closure notices is limited by the conclusion stated in those closure notices solely the market value. Now, there are a number of short reasons why this point should be dismissed. First of all, even on its face, and as the point has been developed in my learned friend's skeleton argument, there is no assertion or argument as to why either the first tier or the Upper Tribunal were correct to decline to decide that issue. And in order
So
for...
why they were incorrect.
Sorry, incorrect, yes. Yes, there are too many negatives. Quite right, my lady, why they were incorrect. And unless the the taxpayers can overcome that hurdle, the respondent's notice point simply can't get off the ground. It's not appropriate for the for the taxpayer to say, well, let's just have another go as a freestanding point before the Court of Appeal. It has to address those prior points, and my learned friend skeleton or respondent's notice just don't do that at all. Secondly, and just for your note, Investec Authorities, tab 17, page 156. This is a Court of Appeal decision that sets out how scope of the closure notice issue should be determined, and you'll see it in paragraph 2 of the head note, and also the relevant paragraphs of 71 and 73 of the judgment. It is for the first tier to decide, considering the facts and circumstances. Now, that's particularly the case where the first tier had more documents than this court has. It's simply not appropriate on any view for the taxpayers to be inviting on the basis of partial documents. And my lady made the very good observation, there isn't even the review conclusion legislation, or in fact some of the appeal legislation in the bundle. It's just not appropriate for the taxpayers to ask the Court of Appeal to determine it for the first time on the basis of this limited material. The third point is, on any view, the taxpayers are wrong about the scope of the closure notices here. And my submission is that when you read the full discussion in Investec, paragraphs 49 to 73 of that judgment, it becomes clear that the Court of Appeal in that case adopted a broad approach to the question of scope. And the point of principle that we say arises from Investec is that the conclusion, the appeal, is not confined to the conclusion and the amendment that might have been expressed on the face of the closure notice. And if I can just make the point very briefly, all of the scope of the closure notice cases are concerning self-assessment returns of either individuals or corporations. Those returns basically return every single item of profit, etc., that either an individual or a company has had during the course of a year. So the very obvious point is, let's assume at the moment, the revenue inquires into my return. It issues a closure notice to say that I haven't actually declared properly all my rental income or rental profits. We then go to the First-tier Tribunal and have an appeal. At that point, the revenue can't pop up and say, oh, we also want to take a point about failure to declare barrister income, because the scope of the closure notice is rental income, and that's that. That makes sense when you're considering the wide range of issues that are in those sorts of returns. On any view, SDLT is completely different. This is a limited return that is all about the SDLT treatment of one specific acquisition by one specific purchaser on a specific date, and that's the beginning and the end of the return. And so all the statements about the relevant protections that arise in the cases about returns which concern far more issues can't simply be transported to this sort of case. And we say that when you read Investec properly, what Investec is really saying is the conclusion is exactly the sort of conclusion I've just given an example of. Here, the only relevant conclusion in a legal sense that comes out from the closure notices, doesn't matter what they say on their face, is what is the SDLT due on this self-contained identified transaction? So, for example,
Well, strictly, that's the amendment.
Yes, sorry, and the conclusion is more is due.
Yes.
But anything other than that, we say are reasons, and the case law also tells us the revenue can add to the reasons, and that last point isn't in dispute.
Yes, I mean, that's arguably quite a broad approach. You're effectively saying that that almost amounts to saying there is no limit. The closure notice scope point imposes no limit for an SDLT return.
And what I would say in response to that is that is correct in circumstances once it's appreciated. The return itself is already very strictly limited, is already very strictly
Yes,
defined.
but you might wonder why the language in the statute is as it is, if that's the case. But anyway.
And the other point we'd make is, just to give an example, what we can't do is somehow try and suggest that the closure notices in this case cover different land transactions, most obviously MPR lease. That would obviously be something that's outside the scope. But we say that when you properly apply those cases to this scenario, this very different type of return, that's the conclusion that ultimately the Court of Appeal reached, because in Investec, the Court of Appeal ultimately decided that anything that was to do with the profits or expenditure concerning those partnership transactions was fair game, and that was broader than the words used in the closure notice. And unless there are any other questions from the court, I think now might be an appropriate moment. Those are our submissions.
Thank you very much indeed. 2 o'clock.
All rise, if able.